Hi everyone. So today's unit that we'll be doing is commercial trust law. My name is Shazia Khan, and we'll be starting off with learning outcome 1 today. So I'll go through a little bit on the unit aims and what is expected of you in each learning outcome, and then we'll start on learning outcome 1. So the unit reference is J6187917. The unit title, as I mentioned, is commercial law, commercial trust law, and it's a level 7 unit, 20 credits, and it's OTHM, level 7 diploma in international business law. And the unit aim is to explore the law of trusts in international context, comparing doctrine in different jurisdictions and exploring the theoretical implications of such differences. So just quickly going through the learning outcomes. So learning outcome 1, we'll be looking at understanding the basic principles of equity as part of the English system of law. And we'll be looking at 1.1, which is to analyse the mechanics of creating express trust, including the rights of beneficiaries. At 1.2, we'll be looking at understanding the functions of a trust device. 1.3, we'll be evaluating and comparing trusts of different types. And 1.4, we'll be evaluating the nature and respective rights and obligations of parties to a trust. Then we look at learning outcome 2, which is to understand the way trusts are used in commercial transactions and how issues are dealt with according to the norms of contract and trust law. Here in learning outcome 2, we'll be looking at 2.1, which is to analyse the context of commercial transaction into contract with trust law and equity. We'll also be looking at evaluating the interactions between contract law and trust law. And also 2.3, explaining how trusts are not bound up with a contract. And 2.4, critically analysing how trustees limit their liabilities. Then we look at learning outcome 3, which is to understand the differences between the rights and duties and powers of trustees operating commercial trust as opposed to those operating family trust. So we look at 3.1, which is to evaluate the powers of a trustee operating a commercial trust and one operating a family trust. 3.2, to look at comparing and contrasting the rights and duties imposed upon a trustee of a commercial trust or a family trust. So these are elements that we'll be looking at in regards to the learning outcomes, and we'll be also looking at the issue around learning outcome 1 first before we carry on. I'll just share the learning outcomes now with you. Just 1 minute. So that was learning outcome 3. Learning outcome 4 is to understand the relationship between the law of trust in an international setting. So we'll be looking at that as learning outcome 4. So we'll just start now with learning outcome 1, and then we'll carry on with the rest of them later. So just 1 minute. So I'll just share that with you now. So we're starting off with the unit commercial trust law, and we'll be looking at unit learning outcome 1 today, which is to understand the basic principles of equity as part of the English system of law. The unit aim, this unit explores the law of trust in an international context, comparing the doctrine in different jurisdictions, as we mentioned before, and exploring the theoretical implications of such differences. So learning outcome 1, indicative content. So we'll be looking at modern trust drafting, principles and nature of equity, trust, tax and estate planning, types of trust, for example, bare trusts, interest in possession trusts, discretionary trusts, accumulation trusts, mixed trusts, settler interested trusts, non-resident trusts. We'll also be looking at beneficiaries' rights, for example, the right to see trust documents, which set out the terms of the trusts, identity of the trusts and the assets, trust deed, any deeds of appointment, retirement and trust accounts. We'll also be looking at the trustees' duties, for example, avoiding conflicts of interest, impartiality between beneficiaries, complying with the terms of the trust and taking control of the trust assets, keeping accounts and preparing tax returns and taking professional advice. The key terminology we'll be looking at is one, which is equity. We'll be looking at principles of equity, equitable remedies, equitable doctrines. Number two, we'll be looking at types of trusts. So like I mentioned, bare trust, interest in possession trusts, discretionary trust, accumulation trust, mixed trusts, settler interested trusts, non-resident trusts. Looking at trust, creation and structure, settler, trustee and the beneficiary. And we'll be looking at the trustee's duties, which is things like fiduciary duties. A duty of care is owed to the individual, duty to avoid any sort of conflicts of interest, duty to act impartially and not take sides, duty to comply with the terms of the trust, duty to take control of trust assets, the duty to keep accounts and prepare tax returns, and the duty to seek professional advice. The beneficiary rights will look at right to access trusts, the right to information about the trust, the right to enforce the terms of the trust, and commercial applications where we'll look at the use of trusts in commercial context, trusts as a form of security, trusts in collective investment schemes, and trusts for employee benefits. And there's a video here on what is equity for you to look at in your own time, and it will look at the issue around what equity is and how trusts are created within English law. So 1.1, analyze the mechanisms of creating trust, including the rights of beneficiaries. So the creation of a trust in English law must involve elements to make the trust valid: capacity, certainty, constitution, and formality. So, there are different ways of creating a trust, an express trust, and firstly, declaration of self as a trustee and the transfer of the property to the trustees. So there are different ways of doing that. And normally express trusts are created, intentionally created by way of a gift or a will. Express trusts can be, as we mentioned, created by either declaration, where one person declares that they hold the property on the trust for another, or through the transfer of property with the intention to make the recipient the beneficiary of the property. So we're looking at the mechanics of creating a trust, and the first one, the intention, which is the cornerstone of creating a trust, is the settler's intention to create a trust, as we've just mentioned. This intention must be clearly manifested, either explicitly through words or implicitly through conduct. The settler must demonstrate a genuine intention to divest themselves of control over certain assets and confer legal ownership of those assets onto the trustees to be held by the benefit of the beneficiaries. And that's the intention of creating express trusts. Then we move on to the certainty of subject matter. So for a trust to be valid, the trust property must be clearly identified and ascertainable. This ensures that both the trustees and the beneficiaries know exactly what assets are held in trust. And this is really important because, it identifies what is in the trust for, the trustee and the beneficiary to know that. Certainty of subject matter prevents ambiguity and potential disputes over the trust property. Certainty of objects. So beneficiaries of the trust must be identifiable either individually by name or collectively as a class. The beneficiary's interest in the trust property must also be certain and defined. This requirement ensures that the trustees know who they are holding the assets for, and that beneficiaries can enforce their rights under the trust. So it's really important that they know, as a trustee, who they are, that the assets are being held for. Certainty of trust and the purpose. The purpose of or purposes of the trust must be clearly defined and lawful. This ensures that trust has a legitimate objective and that trustees can properly administer the trust in accordance with the settler's intentions. So what the settler wants to do, the trustee must follow that. Formalities. So while express trusts generally do not require strict formalities to be created, certain types of trusts, such as those involving land or certain personal property, may need to comply with specific legal formalities. For example, trusts involving land typically require written documentation to be valid. Transfer of legal title. So legal ownership. Transfer of legal title, legal ownership of the trust property must be transferred to the trustee. This transfer distinguishes the trustee's legal ownership from the beneficial ownership held by the beneficiaries. The trustees hold the legal title to the trust property but are obligated to manage it for the benefit of the beneficiaries. They need to compliance with statutory regulations. In addition to the general requirements for creating a trust, certain trusts need to comply with statutory requirements imposed by relevant legislation. So there are laws in place that they must follow to comply with in regards to creating a trust. For example, trusts involving taxation or specific types of assets may need to adhere to statutory provisions to be valid. Rights of beneficiaries. So they have the rights to trust property. So beneficiaries hold equitable interest in the trust property, entitling them to benefit from it according to the terms of the trust. While they do not hold legal title, they have the right to enjoy the fruits of the trust property. Right to information. So beneficiaries have the right to be informed about the trust's terms, the identity of the trustees, and the trust property. They are entitled to receive accurate and timely information regarding the administration of the trust. They have the right to enforce the trust. If trustees fail to fulfill their duties, or if there is a breach of trust, beneficiaries have the right to enforce the terms of the trust. They can take legal action to ensure that the trustees properly manage the trust property and fulfill their fiduciary duties. That's why it's important within the law to have fiduciary that trustees have duties they must follow. The right to inspect documents. So beneficiaries have the right to inspect trust documents, including the trust deed, accounts, and any relevant information, legal documents. This right enables beneficiaries to verify the trust administration and ensure that transparency in its operation. They have the right to sue, so beneficiaries can initiate legal proceedings to protect their interests in the trust property or to challenge actions taken by the trustees that are contrary to the trust terms of their interests. Legal action may be taken to seek remedies for breaches of trust or to compel trustees to act in accordance with their duties. So if they've breached their duties or they have moved away from identifying what their duties are, the beneficiaries do have the right to protect their own assets by initiating any sort of legal action against the trustee. The right to benefit. Ultimately, beneficiaries are entitled to receive the benefits or proceeds of the trust according to their respective interests as defined in the trust instrument. They have the right to enjoy the income, capital, or other benefits derived from the trust property in accordance with the trust terms and conditions. So it's really important that the rights and duties are followed, of the trustee and the beneficiaries. They need to make sure that they are following the legal requirements for their duties as a trustee or a beneficiary, because it impacts on both beneficiary more than the trustee. 1.2. Understand the functions of a trust device. So functions of a trust device. Assessment management. One of the primary functions of a trust device is to facilitate the management of assets. By transferring legal ownership of assets to trustees, the trust device allows for efficient administration and investment of those assets for the benefit of the beneficiaries. This includes tasks such as investing trust funds, managing property, and making financial decisions on behalf of the trust. Asset protections. So trusts can serve as a tool for asset protection. By placing assets within a trust, the settler effectively separates those assets from their personal estate. This separation can shield the assets from certain risks such as personal liabilities, creditors' claims, or potential disputes. Depending on the type of trust and jurisdiction, assets held in trust may be isolated from the settler's personal bankruptcy or legal judgments. Estate planning. So trust devices are commonly used in estate planning to facilitate the orderly transfer of assets to intended beneficiaries upon the settler's death. Through a trust, the settler can specify how their assets should be distributed, establish provisions for minor or incapacitated beneficiaries, and potentially reduce estate taxes or probate fees. Trusts can also provide continuity of asset management beyond the settler's lifetime, ensuring ongoing support for beneficiaries. Privacy and confidentiality. Trusts offer a level of privacy and confidentiality that may not be available through other estate planning mechanisms. Unlike wills, which become public documents upon probate, trusts generally operate outside of the probate process. As a result, the terms of the trust, the identities of beneficiaries, and details of the settler's assets can remain private. This confidentiality can be advantageous for individuals seeking to maintain discretion regarding their financial affairs. So it's a very, very important part of the trusts and the devices to ensure that there's privacy and confidentiality if someone wants to maintain their financial affairs a secret or doesn't want anyone to know about them. So privacy and confidentiality is important. Tax planning. So trust devices can be used for tax planning purposes, allowing settlers to minimize tax liabilities and optimize wealth transfer strategies. Depending on the jurisdiction and specific provisions of the trusts, assets held in trust may be subject to favorable tax returns, such as reduced inheritance or capital gains taxes. Trusts can also facilitate the deferral of or spreading of tax liabilities over time, enhancing overall tax efficiency for both settlers and beneficiaries. Charitable giving. Trusts provide a structured mechanism for charitable giving, allowing individuals to support philanthropic causes in a strategic and impactful way. Charitable trusts such as charitable remainder trusts or charitable lead trusts enable donors to donate assets to charity while retaining certain benefits for themselves or their designated beneficiaries. These trusts can offer tax advantages, income streams, and legacy building opportunities for individuals' commitment to charity giving. Succession planning for businesses. So in the context of business ownership, trust devices can be utilized for succession planning purposes. Business owners may establish trusts to transfer ownership interests or assets to family members, key employees, or other designated successors. Trusts can help facilitate a smooth transition of business ownership, ensure continuity of operations, and provide financial security for both the business and its stakeholders. Special needs planning. So trusts can be structured to provide individuals with special needs or disabilities. Special needs trusts allow settlers to provide financial support for disabled beneficiaries without jeopardizing their eligibility for government benefits or assistance programs. These trusts are designed to supplement rather than replace public benefits and can provide for a wide range of expenses, including medical care, education, housing, and the quality of life enhancements. So in conclusion, overall, trust devices offer a versatile and flexible framework for achieving various estate planning, financial management, and wealth preservation objectives. By leveraging the functions of a trust device, individuals can tailor their planning strategies to meet their unique goals, protect their assets, and provide for the needs of their beneficiaries effectively without any sort of issues or any discrepancies. If the law is followed and the fiduciary duties are followed, and the trust device is a way of providing protection for the beneficiaries. So now we'll be looking at 1.3, and that's evaluating and comparing types of trusts. So the first one we'll be looking at is bare trusts. So just to make it clear, bare trust is sometimes known as an absolute or fixed interest trust, and it's the simplest form of trust that enables you to transfer assets to a small group of people. So when you create a bare trust, you name a specific beneficiary who then will have an absolute right to both the income, usually the interest, and the capital from the trust. And they are usually it's usually used for minor children who do not have capacity to take legal title themselves, a child under the age of 18. So the evaluation bare trusts, also known as simple trust or nominal trust, are straightforward arrangements where the trustee holds legal title to the trust property but has limited powers and duties. The trustee's role is typically passive, with minimal discretion or obligations beyond holding the assets for the benefit of the beneficiary. Bare trusts are relatively uncomplicated compared to other trusts, making them suitable for straightforward asset holding purposes. However, they lack flexibility and may not offer any sort of robust asset management or protection features. Bare trusts are more commonly used to make a gift to a child, but anyone can be named as a beneficiary of a bare trust. However, once they've been named, neither you nor the appointed trustee can change who is entitled to the assets. Although a beneficiary of a bare trust gains control of the trust assets when they reach 18 and 16 in Scotland, the paired trust does not automatically end. Where the beneficiary is an adult, the trustee position is more like a nominee, and they must follow the directions of the beneficiary in relation to the assets held. So bare trusts are less complex. When we look at discretionary trusts, you'll see they are less complex than discretionary trusts. Nevertheless, it's it's really important that when you're looking at trust, that you must seek legal and professional advice, because the lack of flexibility of a bare trust means that it is essentially you that fully understands the additional implications before going down this route. So you need to be taking legal advice to get any sort of trust. Interest in possession trusts. So the evaluation in interest in possession trusts provide beneficiaries with an immediate right to receive generated income by the trust assets. Beneficiaries are entitled to the income as it arises, often for a specified period or for life, with the remainder passing to other beneficiaries upon the termination of the interest in possession. The comparison is that interest in possession trusts offer clarity and certainty regarding income distribution, making them suitable for providing regular income streams to beneficiaries. However, they may restrict the trustee's ability to manage the trust assets dynamically, as their primary focus is on the distribution of the income rather than asset growth or preservation. Discretionary trusts. So discretionary trust, it gives trustees the power to decide how much beneficiaries can get from a trust and when they get it. All capital and income is distributed completely at their discretion. This means there's more flexibility and assets can be protected if circumstances change for any reason. The evaluation discretionary trusts grants trustees broad discretion to distribute, as we mentioned, trust income and capital among a class of beneficiaries. Trustees have the flexibility to adapt distributions based on the beneficiaries' changing needs, circumstances, and tax considerations. The comparison. Discretionary trusts offer significant flexibility and can accommodate various beneficiary scenarios, making them versatile for estate planning, asset protection, and tax optimization purposes. However, the trustee's discretion may lead to uncertainty or disputes among beneficiaries, and the trust tax treatment may be less favorable compared to other trusts, types of trusts. Discretionary trust can be, as we mentioned, tax-efficient solution when passing on wealth to your beneficiaries, ensuring that they're not left out with a large inheritance tax bill or their entitlement to state support or benefit isn't affected. They are also valuable when considering how to pass on property. It's an easier way to pass on your property. In regards to your spouse or your child. Accumulation trusts. So this is literally where the trustees can accumulate income within the trust and add it to the trust capital. And they may also be able to pay income out as with discretionary trusts. So the evaluation accumulation trust retain income within the trust rather than distribute it to the beneficiaries. Income is accumulated, as we mentioned, and added to the trust capital, potentially enhancing asset growth over time. The comparison is accumulation trusts are suitable for long-term wealth accumulation, such as providing for future generations or funding specific objectives. However, they are, by reinvesting income, these trusts can compound growth and maximize wealth preservation. However, they may lack immediate income benefits for beneficiaries and could face tax implications on accumulated income. Mixed trusts. And this is another form of trust. A mixed trust is a hybrid, which is a combination more than one type of trust, typically part discretionary, part interest in possession trust. Different parts of the trust are taxed according to the rules that apply to each one. There's no special rules that apply to this one. So the evaluation of mixed trusts. Combine elements of different trust types, as we mentioned, allowing for customized arrangements that cater to specific objectives or beneficiaries' needs. They may incorporate features of bare trusts, interest in possession, trusts, discretion trusts, or other trust structures. The comparison is that mixed trusts offer a high degree of customization and versatility, enabling settlers to tailor trust provisions to suit their unique circumstances. However, their complexity may require careful drafting and administration to ensure clarity and effectiveness in achieving intended goals. An example of a mixed trust might be, for example, it might give the beneficiary a right to the income called an interest in possession of half of the trust fund. So it's a mixture of all the actual trusts in one. So, but then the law applies to each trust differently. So you need to take that into account. And when you're drafting this, you need to be really careful when you're looking at mixed trusts. Settler interested trusts. So the evaluation is settler interested trusts involve the settler retaining certain interests or benefits in the trust, such as the right to income or the power to revoke or amend any sort of trusts. These trusts may have implications for tax treatment and asset protection, depending on the nature of the settler's trust interests. The comparison is settler interested trusts provide flexibility for settlers to maintain some level of control or benefit from trust assets while still achieving estate planning or asset protection objectives. However, the settler's interests may complicate trust administration and could impact the trust's effectiveness for certain purposes. Non-resident trusts. So the evaluation of non-resident trusts are established in jurisdictions where neither the settler nor the beneficiaries are tax residents. These trusts may often offer favourable tax treatment, asset protection benefits, or confidentiality provisions compared to trusts domiciled in a high tax or regulated jurisdictions. The comparison here is that non-resident trusts can provide tax advantages and enhance privacy for settlers and beneficiaries, particularly for those individuals with international assets or cross-border interests. However, they may also raise compliance complexities and regulatory considerations requiring careful structuring and ongoing management to ensure compliance with relevant laws and regulations. 1.4. Evaluate the nature of respective rights and obligations of the parties of trust. So respective rights and obligations of the parties in trust. So the settler, the rights that the settler has. The settler retains the right to establish the trust and define its terms, including selecting beneficiaries, specifying the trust property, and determining the trust's purpose. They also, in some jurisdictions, the settler may reserve certain powers or benefits for themselves, such as the power to remove or replace trustees or the ability to receive income from the trust. The obligations for them are that the settler has the duty to create the trust with the clarity and honesty, ensuring that the trust terms are legally enforceable and accurately reflect their intentions. So they must transfer legal ownership of the trust property to the trustees and adhere to any formalities required by law for trust creation. The trustees' rights and obligations. So the trustees have the right to possess and manage the trust property in accordance with the terms of the trust and the applicable laws. They may receive reasonable compensation for their services unless the trust instrument expressly provides otherwise. The obligations of the trustees have a fiduciary duty to act in the best interests of the beneficiaries, exercising care, loyalty and prudence in managing the trust property. They must administer the trust in accordance with the trust instrument and applicable law. So they must follow what the laws say in regards to their duties, avoiding any sort of conflicts of interest and self-dealing. Trustees are obligated to keep accurate accounts, provide regular reports to the beneficiaries, and act impartially among beneficiaries. So, you know, they can't take sides or be biased. The beneficiaries' rights. So beneficiaries have the right to enforce the trust and ensure that trustees fulfill their duties and obligations. They are entitled to receive distributions from the trust according to the terms of the trust instrument and their respective interests. Beneficiaries have the right to information about the trust, including trust documents, accounts, and any sort of other relevant information that is needed. The obligations of the beneficiaries. Their beneficiaries typically do not have direct obligations under the trust instrument. However, they may have responsibility to cooperate with the trustees and other beneficiaries to facilitate the trust's administration. In certain circumstances, beneficiaries may have obligations to act in good faith and not interfere with the trustee's proper management of the trust property. Other parties, if applicable. So the protector, if appointed, a protector may have rights to oversee the trustee's actions and ensure compliance with the trust terms. Advisors, such as professionals such as lawyers, accountants, or financial advisors, may have the rights to provide any sort of guidance and advice to the trustees, but generally do not have the direct obligations under the trust instrument. The nature of respective rights and obligations. So the nature of these rights and obligations is rooted in principles of equity and fiduciary duty, which require parties to act with honesty, integrity, and diligence in managing trust affairs. Rights and obligations. Rights and obligations are typically outlined in the trust instrument, but also be governed by applicable laws. And legal precedents. The relationship between parties is categorized by trust and reliance, with trustees holding legal title to the trust and the trust property, but acting in the best interest of the beneficiaries. While the settler establishes the trusts and sets its parameters, trustees have a significant role in managing and safeguarding any sort of trust property, and also the beneficiaries have enforceable rights. So, you know, both parties do have rights in regards to their obligations and, you know, in regards to enforcing any sort of rights to ensure that the trustees fulfill their duties. So it's really important when you're looking at that to make sure that the trustees are fulfilling their duties and literally, you know, because, you know, if they're not, they're breaching their fiduciary duties. The rights and obligations of the parties may vary depending on the type of trust. So, you know, the specific terms of the instrument. So the terms may be different, you know, each term may be, you know, it's up to the beneficiary what terms they put in there in regards to applying any sort of, you know, making sure that the trustee actually follows what the beneficiary has put in there. And governing law of the jurisdiction of the country, you know, so they need to make sure that they follow the laws of the country, which is, for example, you know, in the UK, they need to look at the laws in regards to trust, and for the trustee to follow the their duties, fiduciary duties, you know, and not to breach them. You know, it's really important that, you know, someone, when they do have the issue of getting a trustee, they need to make sure that the trustee will follow the duties in regards to, you know, looking at confidentiality, privacies, you know, following the formalities of the law and the legal requirements. You know, they need to make sure that, you know, they are following the requirements, but also following the law in regards to, you know, meeting the formalities and the regulations. So we finished to Learning Outcome 1 now, in regards to looking at the issue around the different types of trusts, the rights and responsibilities of beneficiaries, settlers and trustees, and what their rights are in regards to the laws and the jurisdiction of the country. So they need to make sure that they are following the laws and the requirements that are needed. The references we've used for today for Learning Outcome 1 are just listed below, which is Property in Land by Ellickson, Gilmore, Security Interests in Personal Property, University of Pennsylvania, Gray, J, The Nature and Sources of Law, Hannock, Dagan, Unjust Enrichment, A Study of Private Law and Public Values, Cambridge University Press. We've also looked at Herkoff, Property as Institution for Resources, Introduction to Law and Social Inquiry, Honor, Ownership in AG Guest, Essays in Jurisprudence, Jackson, Problems of International Trust Law. We've also looked at Jensen, which is the nature of equitable property rights, Jones, the nature of property and property rights, Pinay, the idea of property in law, Radin, property and personhood, Robson, trust and patrimonial property, trust and trustees, Siegel, the nature and functions of property, and Simmons, the nature of property, origin, structures and rationale. So these are some of the really good resources that you could use when it comes to completing your assignment. So also refer to any sort of ebooks and journals on the Moodle for this unit. Make sure you go on there for any sort of further reading. It will be additional reading and ebooks on Moodle for you to refer to. Any sort of inquiries or anything that you have, please email learnerwork@ukvarsity.co.uk. And when it comes to submission of your assignment, which is 2 weeks after all the learning outcomes have been completed, you will need to submit your work to learnerwork@ukvarsity.co.uk. So if you have any questions or anything, you know, go on to emailing learnerwork@ukvarsity.co.uk. And also if you need to have any additional reading, any journalings or anything, it will be on the Moodle page for this module. Okay, so thank you for attending today's session, which is Learning Outcome 1. The next session we'll be doing is Learning Outcome 2, which is tomorrow. Thank you.